And one, Akwa Ibom State University. So the Vice Chancellor, Akwa Ibom State University. 3, Professor Eno Ibanga. 4, Professor David Eka, Dean, Faculty of Arts, Akwa Ibom State University. 5, the Registrar, Akwa Ibom State University. 6, the Governing Council of Akwa Ibom State University. My Lord, the claimant is online. The defendants are all absent, my Lord.
First defendant is present, please.
All the
My
defendants.
Lord, the claimant is present. The defendants are absent.
Sir? Yes,
The
appearance.
The defendants are represented
Appearance.
by someone.
Appearance.
Is represented.
Represented by who?
Yeah. May I please the honorable court? My name is Joseph Oloko, my lord.
Yes, I'm with you. Are you appearing?
My name is
Yes.
Ekemeni
Ekemeni Udim.
I appear for all the defendants. Lord, the defendants are represented by the head of legal who is in court.
Represented by who?
So mention your name.
Why is the representative of the defendant?
Ime Udofa is the name.
You say?
Head of legal, sir.
I said, where is he? Let him raise his hand. Let me see. What is your name?
Ime Udofa.
Ime Udofa.
Ime Udofa.
Ime Udofa.
Udofa, my lord, U-D-O double F-A.
Double S-A.
Double F. Double F-A.
Udofa.
Ime Udofa. I-M-E, my lord. U-D-O double F.
Ime Udofa.
Yes, my lord.
F-A. Okay. What is your status?
Director of Legal Services.
Yes, this matter is for judgment. The judgment is ready and it will be read virtually.
As the court pleases.
Sir. Yeah, name it careful. Abi? Okay, it's okay, don't worry. Don't worry. Give one day cool.
Please, you should mute yourself so that you will not interrupt the proceeding. The person talking. Yes, this is the judgment of the court by the general form of complaint dated 16th day of April 2020 and filed on the 17th day of April 2020, accompanied by statement of facts, witness statement on oath, list of witnesses, list of documents to be relied on, and photocopies of documents to be relied on to be tendered in evidence at the trial. The claimant instituted this suit against the defendant claiming reliefs as follows. 1, a declaration that the dismissal of the claimant from employment of the first defendant is unlawful, null and void, and of no effect whatsoever. 2, a declaration that the purported dismissal of the claimant from the employment of the defendant negates the fundamental rights provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended. 3, a declaration that the claimant is still in the service of the defendant. 4, an order setting aside the purported dismissal letter dated 30th day of January 2020 issued to the claimant. 5. An order compelling the defendant to reinstate and or restore the claimant to his post as an associate professor in the service of the first defendant with all his rights and entitlements of the office. 6. An order compelling the defendant to pay the claimant all the salaries due to him from the period he was suspended until judgment and henceforth. On the 10th day of October 2023, the claimant testified in proof of his case as CW1. CW1 adopted 2 witness statements on oath as his evidence in this case. 22 documents were also tendered by CW1. They were admitted in evidence and marked as exhibit CW1A to CW1Z. On the 24th day of October 2023, CW1 was cross-examined by counsel for the defendant. Thereafter, he was discharged in the absence of re-examination. On 1, Emeobong Enemi testified as CW1 in proof of the defense of the defendant. DW1, after identifying witness statement on oath, adopted same as his evidence in this case. Documents were tendered in evidence and marked as exhibit DWA to DWS. DW1 was cross-examined by counsel for the claimant. Thereafter, he was discharged. Another witness of the defendant was one Ime Susan Udopia, Director Legal Services of the defendants. One document was tendered through this witness. One document was tendered through this witness. It was admitted in evidence as exhibit DW2A. DW2 was cross-examined by counsel for the claimant, and at the end, he was discharged. The case of the claimant: by the letter dated 21st day of March 2016, the claimant joined the services of the first defendant on probation as a senior lecturer in the Department of Philosophy. The appointment of the claimant was confirmed on the 8th day of April 2018. Apart from the regular lectures, the claimant was appointed to serve in several administrative positions in the first defendant. The claimant was also promoted to the rank of associate professor by the council of the university, the sixth defendant. According to the claimant, his travels started when a letter dated 18th day of February 2019 titled "An Appeal for the Recomputation of my result from year 2 to 4 to exclude courses which I should not have offered as a direct entry student to enable me graduate in 2017-2018 session." Written by one Glory M. Akpan, a student in the Department of Philosophy. The said appeal was forwarded to the claimant for comment. Following the response of the claimant to the said Glory Akpan then wrote a petition against the claimant titled Petition of Victimization on ground of refusal to concede sexual harassment advancement made on my person by Dr. Emmanuel Jerome Udokan of the Department of Philosophy, Obio Akpa campus. Following his response, the claimant received a text message inviting him to appear before a panel of investigation, which he did. A petition dated 23rd day of April 2019 was written against the claimant by an anonymous and non-existent Thompson Samson. And instead of serving the claimant with the petition to reply as usual, he was rather issued with a query dated 19th day of July 2019, which contained excerpt of the petition. The claimant replied the query. The claimant was served with another query dated 28th day of August 2019. The claimant replied on the same day. 6 days after his reply to the query, he was issued with a letter suspending him dated 3rd of September 2019. Thereafter, the claimant was invited via a text message to appear before the administrative panel of inquiry, which had, among others, Professor Idongis Isaac, Professor Anete Akpan, Professor Godwin Omoite, and Barrister Iniobong Ikpat as members. At the hearing, claimant was subjected to verbal abuse by the panel and was not given opportunity to state his case. The report of the investigation was not made to him. The claimant was again directed via text message to appear before the council disciplinary panel, consisting, among others, Dr. Mrs. Gloria Okpan, Professor Idongis Isaac, Professor Anete Akpan, Professor Eno Oton, Professor Omorin as members. The panel, substantially made up of members of the previous panel, did not act differently, as the claimant was subjected to further abuses and denial of opportunity to state his case. The members of the panel who were in the administrative panel sat on appeal over their own decision. The claimant was served letter of dismissal from service on 30th day of January 2020. The case of the defendant. The claimant was appointed as a lecturer in the Department of Philosophy. In the course of his employment, he was appointed head of department. He was also promoted to the rank of associate professor of philosophy. During the 3 years, the claimant served the first defendant. Several petitions were received against the claimant from students of the department where the claimant was lecturer. The complaints against the claimant include sexual harassment, collection of school fees from students, and embezzlement of the fees. Other complaints include dismissal and termination of employment in previous places of work, sale of unauthorized textbooks, compelling students to pay departmental dues of 700 as against the Senate approved 500 naira, and irregularities in examination computation. The claimant was queried. He replied. Thereafter, he was suspended. A panel of investigation was set up by the Vice Chancellor. The claimant honored the invitations. The persons who made the allegation were also invited. The case of the claimant was also referred to the Staff Disciplinary Committee, which is an arm of the Governing Council of the University. The Governing Council then sat and reviewed the two reports and made an assessment of the entire case reported against the claimant. The defendant maintained that the claimant was offered ample opportunity to defend himself. He was therefore given fair hearing in line with the conditions of service and in line with general provisions of the requirement of fair hearing. The allegations against him were made known to him in writing. He was given opportunity to respond in writing and appeared before the different panels of inquiry to state his case. He was given opportunity to confront his accusers. The claimant was dismissed based on overwhelming evidence of gross misconduct against him as shown above. The allegation that the Vice Chancellor hated him is false. In reply to the statement of defense, the claimant stated that he was appointed on the 21st day of March 2016, promoted by the letter dated 28th day of September 2019, while his confirmation of appointment was on the 8th of April 2018 by the letter dated 17th day of January 2019. Nearly a period of almost 3 years without any issue or query. He served without any query or issues. All the petitions against him were a product of his refusal to accede to the demand of the third defendant, who was the boss alter ego of the first defendant. The claimant maintained that he was not dismissed from any of the universities listed by the defendant in paragraph 7, 8, 9, and 10 of the defendant's statement of defense. There was no provisions in the conditions of service of first defendant to mandate the defendant to dismiss on suppression of record, as there was no provision in the condition of service to that effect. According to the claimant, paragraphs 12, 13, 14, 15, 16, 17, 18, 19, and 20 of the statement of defense were crafted from were crafted and doctored from the undated report of the panel of investigation and the purported internal memo titled the Report of Staff Disciplinary Committee, dated the 26th day of November 2019, which memo is from the chairman, State Staff Disciplinary Committee to the Registrar Secretary to Council. It is further stated by the claimant that though he appeared before both the panels, the content of the attached document, mostly the questions, that is the report, mostly the questions and answers of the persons who appeared before the committee does not represent the true questions and answers before the panel. The content were adopted to specifically suit the defendant's desire. The submissions of the defendant. Okemiri Odin, Esquire Counsel for the defendants, adopted the final written address of the defendant as his argument in this suit. In the written address, a single issue was formulated for determination, with whether claimant was given fair hearing prior to his dismissal from the service of the Akwa Ibom State University, and whether his dismissal was done in compliance with the provisions of conditions of service applicable to members of staff. In arguing the sole issue, counsel submitted that there is ample evidence to show that the claimant was afforded fair hearing by the defendant before he was dismissed from the employment of the university. His allegation, therefore, that he was denied fair hearing is not supported by evidence. According to counsel, several petitions were received against the claimant from the student he taught in the Department of Philosophy. Some of the petitions have been tendered in this honorable court and admitted in evidence as Exhibit DWL is a petition from a student with the title Petition of Victimization on ground of refusal to consist of sexual advancement made on my person by Dr. Emmanuel Jerome Udokan of the Department of Philosophy of your Akpa campus. In the petition, a student, Ms. Bulori Monde Akpan, alleged that the claimant repeatedly asked her for sex, and when she refuses, the claimant will threaten, and if she refuses, the claimant threatens that the student will not graduate and go for NYSC. Exhibit DWC is another petition still against the claimant. The petition is titled An Appeal for Assistance. The petition was written by one Miss Ikara Susan Hillary. She alleged that she went to the claimant as HOD of her department to complain, to report that she was unable to pay school fees on time, and that at the time the school fees was given to her, the portal had closed. The claimant then offered to assist her in the payment despite the closing of the portal. The claimant collected the sum of 59,000 from her, but failed to pay the fees, and also failed to make a refund of the sum to her, despite repeated demands. The claimant, not being the bursar, had no right to receive school fees from students, and failing to make a refund to the student. In another brief, the university received petitions from Aboni Godson Onome, dated 28th day of August 2019, captioned Letter of Appeal, pleaded at paragraph 11, sub 3 of the deposition of DW1, and tendered along with the bundle of exhibit on 27th day of November 2024. In the said petition, the petitioner alleged that he was unable to raise money and pay his school fees within the time allowed by the university, that at the time he was able to raise the funds, the portal had been closed, that he then approached his HOD, the claimant herein, and sought to know what to do in the circumstances. But the claimant asked him to pay the money to him with a promise that he will find his way around as HOD around the situation despite the closing of the portal. The student handed over the sum of 147,000 to the claimant. The claimant did not pay the fees for the student as he promised, and did not also refund the money to the student despite repeated demand. The university also received information that the claimant had been dismissed at least in one university where he previously worked, while his employment was terminated in at least 3 universities. The university also received petition from students of unauthorized sale of books by the claimant despite the practice being prohibited by the management. The university also received petition from students that the claimant had compelled students to pay departmental dues over and above the approved threshold. There was also a report of observed irregularities in examination that were under the custody of the claimant. Counsel submitted that based on the above complaints and petitions, the university then afforded the claimant an opportunity to be heard. He was first issued with queries from the office of the registrar. The 2 queries had been admitted and marked as Exhibit DWL and Exhibit DWS. In the queries, the allegations made against the claimant were clearly stated, and the claimant was given 48 hours to respond to the queries. The claimant responded accordingly to the queries within the time stipulated. See his letter titled Query dated 28th of August 2019 and addressed to the registrar and attached to the claimant's complaint of 16th day of April 2020. His reply: the claimant took time out to respond to all the allegations made against him in the registrar's queries. He denied extorting money from students, denied selling books, denied collecting school fees from students, and denied even suppressing facts of previous employment, and added that he never worked in the universities listed in the query. This was the claimant taking full benefit of fair hearing opportunity given to him at this stage. The claimant maintained this point. He could not continue with the denial. Therefore, the claimant has been afforded fair hearing. The university was not satisfied with the explanation in the queries, in the answers to the query, and in the exercise of the power vested in the condition by the conditions of service. The Vice Chancellor constituted a panel of investigation to investigate the allegation made against the claimant. The panel sat, invited the claimant and his accusers. The panel confronted him with the allegation against him. The persons invited were allowed to interrogate him, and he in turn was allowed to interrogate the persons. The panel members also interrogated him. The panel then submitted its report to the Vice Chancellor and made necessary recommendations for action. The report of the panel was admitted in evidence and marked as Exhibit DWA. It is submitted that the said report carries a great details of proceedings of the panel with sufficient evidence of fair hearing afforded the claimant. The panel found the claimant culpable on most of the allegations. It is then recommended that the claimant's conduct is in contravention of the condition of service and the claimant should be dismissed from service. It is submitted that the appearance of the claimant at the panel was another opportunity for him for fair hearing given to him, to which the claimant took sufficient advantage of by actively participating at the proceeding and asking his accusers questions as shown in the report and also responded to. Upon the submissions of the report to the Vice Chancellor then forwarded it to the Staff Disciplinary Committee for further investigation. The Staff Disciplinary Committee is the standing committee of the Governing Council. The committee invited the claimant along with his accusers and afforded them the opportunity to be heard. The claimant expressed himself freely, and in the end, the committee submitted its report. The said report was admitted in and marked as Exhibit DW2A. The committee noted in the report inter alia that Dr. Emmanuel Udokan, having been dismissed from service in Redeemers University, was ab initio not employable under the laws of the land. Thus, his employment and subsequent promotion to the rank of associate professor was a nullity. The university should dismiss Dr. Udokan from service and withdraw the rank of associate professor forthwith. End of quote. Still in the report, the claimant was found capable of collecting of school fees from students on the guise that he will pay the school fees for them after the portal had closed. He was also found culpable on other allegations leveled against him. He was, however, absolved of the allegation on sexual harassment. On being cross-examined by counsel for the defendant on 24th day of October 2024, the claimant admitted allegations were indeed made against him, that he was issued with queries, that he submitted his replies to the queries within the time stipulated, that a panel of investigation was set up to investigate the allegation made against him, and that he appeared before the panel upon the invitation, that he was asked questions and made to face his accusers at the panel, that he also appeared before the staff disciplinary committee on same allegation, that the above took place before he was dismissed from service of the university. It is the submission of counsel that from the totality of the above, together with the documents tendered and decisions of the admissions of the claimant on oath, there is sufficient evidence to show that claimant was indeed afforded fair hearing before his dismissal from teaching service of Akwa Ibom State University. Counsel asked the court to so hold. It is also submission of counsel that a panel of inquiry and investigation is a fact-finding panel. Its primary mission is to investigate allegation of infraction made against a staff of an establishment. It is unlike the court of law, it does not embark on a trial and conviction. Its mission is rather to investigate and uncover evidence. The panel of inquiry is not expected to embark on proof beyond a reasonable doubt before a recommendation can be made. Once there is reasonable evidence to show that the panel carried out its mandate and afforded the staff ample opportunity to be fairly heard, the panel would have been said to have achieved its mandate. On this, counsel refers to the case of Oluwatoyi versus Civil Service Commission of Ondo State, where the Court of Appeal held it is well-established principle of law that an investigative panel of inquiry, not being a court of trial, it is sufficient if it gives any person who featured in the inquiry the opportunity of making some representation orally or in writing before it. In this case, the two administrative bodies above went beyond the surface and carried out thorough investigation of allegations that were made against the claimant. He was invited, his accusers were also invited, he was given the opportunity of making his representation at the panel. We counsel submitted that exhibits DWA and the staff disciplinary committee of the report of the staff disciplinary committee and that an exhibit DW2A had duly satisfied what the law requires of them as an administrative body or panel of inquiry. The claimant was dismissed for allegations for which he was queried in the query of 28th day of August 2019, exhibit DWL. The claimant was queried inter alia for unauthorized sale of books, extortion of money from students, and suppression of record of previous appointment, where he was either dismissed or terminated. The investigation panel confined themselves to this allegation. Questions were asked and interrogatories were made. In the end, the allegations were found to have indeed taken place. The claimant was then dismissed based on these established facts, and the reasons for the dismissal are shown in the letter of dismissal, exhibit DWQ, tallies with the query. The defendants thus complied with another requirement of the law, and the claimant cannot be right to say that he was denied fair hearing. The other leg of the questions which is whether the laid down procedure was followed by the defendant in dismissal of the claimant from employment of the university. To answer this question, resort must be made principally to Exhibit DWH, the condition of service, which represented the social contract and pact between the claimant and its staff, between the university and its staff. Counsel then asked rhetorically what is the procedure laid down in the document. Counsel submitted that this ought to have been pleaded by the claimant, but since not been pleaded by him, he thus has not shown by his pleading what the proper procedure is, so as to enable the court to compare and see breach of the procedure that was used in his case. We submit that an unpleaded fact cannot give rise to a cause of action. We referred the court to the case of Nigerian Romanian Wood Industries Limited and Akin Gulu Bay. Counsel also refers to the case of Kwara State Civil Service versus Abiodi, where it was held that, turning to the main issue for determination, there is no doubt, as was rightly contended by the learned DPP on behalf of the appellant, that on the authority of Ibama versus SPDC Nigeria Limited, the Supreme Court had expressly stated that the onus is on the employer who alleges the wrongful termination of his employment or his wrongful dismissal by his employer to place before the court the terms of employment before proceeding to prove manner in which it was breached by the employer, and that is, it is not the duty of the dependent to so do. See also Amodu versus Amode for Agbaje JSC. It is submitted that the claimant in this case has not pleaded in any of the paragraphs of the complaint the way and manner, the proper procedure by which he can be removed from office from the employment of the first dependent. He has just failed in his duty as required of him by law in the suit where the claimant is alleging wrongful termination of employment. This lapse is fundamental, and the court of law can rightly arrive at the conclusion that the claimant has failed to prove his case. In the event that his lordship is of the view that claimant lapse should be overlooked, counsel proceeded to argue that the procedure in the conditions of service exhibit DWH for discipline of staff member of Akwa Ibom State University was stated in chapter 3 of exhibit DWH, which provide for discipline. In article F at page 30 of the exhibit, the procedure for discipline has been outlined as follows. I will keep reading the procedure. Counsel submitted the above provisions or procedure was strictly followed. The allegation against the claimant were in category of serious and gross misconduct. The condition of service, definition of category of misconduct, the allegations were grave, and the explanation given by the claimant reply title inquiry and dated August 28 did not give satisfactory explanation. The said reply to the query was tendered and marked as exhibit CWS. The university then took a decision to call for an investigation into the grave allegation so as to do so as to also give the claimant an opportunity to defend himself. Exhibit DWA shows that an administrative panel of inquiry was constituted to investigate the claimant. The exhibit report of the panel carries the names of the chairman, members of the and members of the committee, term of reference as duration of the investigation. The panel invited the claimant, and the panel invited the claimant and his accusers. The claimant was able to confront his accusers and was also able to make his defense. The panel made its findings and also made recommendations to the Vice Chancellor for further action. The claimant himself has accepted in his pleadings and at cross-examination that he was invited to the panel and he was there. He was heard. It is submission of counsel that the action of the university satisfies the requirements of the conditions of service. Counsel praised the court to so hold. Counsel submitted that he was also invited by the staff disciplinary committee, which he appeared, and he was accorded fair hearing. It is submission of counsel that there is no other procedure in the condition of service for the discipline of staff members of Akwa Ibom State other than the above three itemized procedures. These procedures were duly followed by the defendants. The dismissal is therefore not unlawful as claimant want the court to believe. The dismissal is therefore not unlawful as in this case, the claimant was duly accorded fair hearing. He was allowed ample opportunity to be heard. Counsel relied on the case of Imonike versus Unity Bank, where Rod Bible JSC as his name was stated, accusing an employee of misconduct, etc. by way of query, and allowing the employee to answer the query, and the employee answer before a decision is taken, satisfies the requirement of fair hearing or natural justice. The appellant was given fair hearing. Counsel also relied on the case of Udo versus Civil Service Commission of Akwa Ibom State. According to counsel, in the case at hand, the claimant was afforded fair hearing in accordance with the procedure above laid down, decided authority. Having regard to the entirety of the above, counsel submitted that the question of whether procedure or requirement of the conditions of service has been followed in dismissal of the claimant has been answered in the affirmative. The question of whether the claimant has where the conditions are complied with, the court of law will not force an employee on unwilling employer whose conduct has become reprehensible and even scandalous to the employer. This being the case, counsel pressed the court to dismiss the suit in its entirety and affirm the dismissal of the claimant from service of Akwa Ibom State. Counsel also stated that the claimant has failed to prove his case to be entitled to relief sought and humbly submitted that the option available to the court is to dismiss the suit in its entirety against the claimant. In the Makan versus Hangem, it was held that on the proper order the court could make where a plaintiff fails to prove his case, that is, dismissal of the case. See the case of Omere De versus Eliazu, see also Yusuf versus Adegoke, see Agana versus Oa. In Osuji versus Ekiocha, the Supreme Court far counsel at the end asked the court to dismiss the case of the claimant, the submissions of the claimant. Joseph Olopu Esquire, counsel for the claimant, adopted the claimant's final written address as his argument in this suit. In the written address, a single issue was formulated for termination to it, whether the composition of the administrative panel of inquiry and staff disciplinary committee whose overlap of membership created a likelihood of bias against the claimant. In arguing the sole issue, counsel submitted that the claimant's employment under first dependent was one with statutory labor and guided by the first dependent conditions of service. Chapter 3 of the condition of service provide for description of self service. In arguing the sole issue, counsel submitted that the claimant's employment under the first dependent was one with statutory labor and guided by the first defendant's condition of service, XBCW 1B. Chapter 3 of the condition of service provide for discipline of staff, particularly paragraph 3.1 F2 provides for setting up of administrative panel of inquiry with names and designation of the members clearly indicated. The said panel was duly set up by the with the membership of Professor Idongis Isaac, Professor Mrs. Enoje Otong, Professor Aniete B. Akpan, Professor Godwin T. Umoite, and Barrister Emio Bong Ipak. The disclaimer was thoroughly, according to the claimant, he was thoroughly abused by the panels. Instead of asking questions and was allowed, instead of panel members, abused by the panel members. And was not allowed to be present when his accusers were being questioned, even though the report says otherwise. The claimant took consolation that at the disciplinary committee, he will be meeting different set of persons in the committee who will listen to him. At the conclusion of the administrative panel of inquiry, purported investigation, the claimant was invited to appear before staff disciplinary committee. Where the claimant was surprised to see most of the members of the administrative panel, except the secretaries, were also members of the staff disciplinary committee. The fulcrum of the claimant's complaint can be found in paragraphs 24, 25, 26, 27, 28, 29, 30, 31, 32, and 33 of the statement of facts and statement on oath of test CW1. According to counsel, in an effort to debunk the claimant's complaint and misleading house the report falls short of committee's report as provided by paragraph 3 F2 of XBCW1V. It does not contain the names of the committee members, neither is the report signed by all the members who took part in the committee, unlike the report of administrative panel of inquiry. The real essence of not listing the names is to deny this honorable the opportunity of comparing the names of both two committees. Council relied on section 167 of the evidence to establish that evidence which could not be and is not produced, if produced, it will be unfavorable to the person who is held it. It is submission of council that suppression of names of the committee members in the said disciplinary committee Council also referred to the case of Pogwade versus Akande in support of section 167D of the Evidence Act and other cases cited there. The council submitted that DW2 was the secretary of State Disciplinary Committee and was person who produced the report. Council submitted that the evidence exists that the committee was set up by the first dependent. DW2 at all material time can produce the names of the committee members. The names are in the existence and in the custody of the first dependent. These facts satisfy the prescribed condition. Council asked the court to hold that the claimant, the defendants withheld evidence. He also relied on the case of First Bank of Nigeria PLC and another versus Adeosun Business Investment Limited and others. Council also submitted that in his effort to further suppress his material fact, DW2, who was the Secretary of Staff Dismissal Committee, under cross-examination claimed he could not remember the names of the committee members, but can remember only two names of the members of the committee, which he named as Professor Omoiti and Professor Inyoriyoko. Council submitted that Professor Omoiti also served as in the administrative panel of inquiry, CXBDWA. It is submission of council that members of the administrative panel of inquiry also sat on the staff disciplinary committee as an appeal against their own decision. They submitted that the essence of an appellate panel in the name of staff disciplinary committee was to review the report of the lower panel as to exclude according to council, the implication of not following due process laid down procedure arrest of discipline of an employee whose employment has statutory labor, as stated by the Court of Appeal in the case of Oloe Kire. It is submission of council that the empaneling of the same persons on both panel raises likelihood of bias and negates the principle of nemo judex in causa sua. The claimant had contended in paragraph 25 and 27 of both statement of facts and statement of oath that both sessions of the panel was an abusive session, and that he was not given opportunity to study his own side of this case in defense of himself. At the staff disciplinary committee, which is appellate committee, the views of some members who now transmute to compel this appellant committee cannot be different. At the staff disciplinary committee, which is the appellate committee, the views of same members who now transmuted to empanel the appellate committee cannot be different, having established a case against the claimant of the lower panel. He relied on the case of Prutec versus Agbo to support his submission that there was violation of his fair hearing. It is also submission of counsel that the principle of fair hearing, which claimant was denied, is at the fabric of action. He refers to the case of Bogadu and another versus Sule and others, where the Supreme Court Pakekere Ekun JSC now GCN, now CJN, has this to say: the principle of fair hearing enshrined in our constitution demand that every party to a cause or matter has a right to be heard, a decision to give effect to him or his interest. He is not only entitled to hearing, he is entitled to fair hearing. In Towo versus University of Calabar Teaching Hospital, it was stated that as follows: the principles of hearing as envisaged in the right of fair hearing granted by Section 36 of the Constitution as amended, applies to determination of parties' civil rights and obligation by a court of or tribunal established by law as provided by the section. Section 36 provide in determination of civil rights and obligation, including any question as to determination or against any government or authority, a person shall be entitled to fair hearing within a reasonable time by a court of by a court or other tribunal established by law and constituted in such a manner as to secure its independence and impartiality. However, in the case of administrative panel of inquiry set up for the primary purpose of fact-finding, in respect of the submission of counsel that the overlook of both panel create denial of fair hearing, that the members of administrative panel of inquiry who had already established a case by purported report against the claimant and thereafter sat on the staff disciplinary committee as the arbiters in the appellate committee cannot be said to be fair in their judgment in compliance with the provisions of Section 36 of the 1999 Constitution. Counsel submitted that the effect of denial of fair hearing is that the entire proceedings will be rendered nullity. It does not matter whether the panel is administrative or quasi criminal in nature or body or a body. See the case of Akande versus IBB University Lafayette. See also Arioli versus Counsel relied on the cases of Akande versus IBB University, Lafayette, and another, Arioli versus Muraiwo, Elemo, and others, Duke versus Government of Cross River State, and others, to support his submission that there was breach of his fair hearing in the proceedings of the two committees. Counsel asked the court to grant the relief sought by the claimant and discountenance the submissions of counsel for the defendants. A reply to the claimant's written address, counsel for the defendant submitted that at paragraph 6, paragraph 3.5 of the final written address of the claimants, counsel has submitted that in an effort to debunk claimant's complaint and to mislead the Honorable Court, the defendants through DW2 tendered exhibit DW2A, which is the purported report of staff disciplinary committee. The report falls short of the committee as provided, committee report as provided in paragraph 3F2 of exhibit CW1B. It does not contain the names according to counsel, in real sense, not listing of names is to deny this honorable court the opportunity of comparing names on both panels. In essence, the claimant counsel submission is that a report of the panel of investigation tendered and admitted the names of the chairman, secretary, and members of the panel have been listed, whereas only the name of chairman and secretaries has been listed in the report of the Staff Disciplinary Committee. The reply: Council submitted that at Exhibit DW2A, report of Disciplinary Committee Council submitted that this honorable court should respectfully make a recourse to the conditions of service as so as to be properly guided by the provision regarding the two administrative panels, starting with Chapter 3, Paragraph F2, which provide for investigation shall be instituted in the case of serious and or gross misconduct, and the members of staff informed in writing to avail himself of the opportunity given for proper self-explanation. Investigation shall normally be done by an administrative panel of inquiry, with the names of designation of members clearly included, and the terms of reference and duration of the investigation spelled out. I'm sorry, Council, I have technical hitches, but thank God I'm back. I will continue from where I stopped. Council further states that Staff Disciplinary Committee of the University is standing committees of the Senate and Governing Council. Council refers to Section 8 of the Akwa Ibom State University Law, which provides that there shall be a joint committee of the Council and the Senate to be known as Staff Disciplinary Committee for the discipline of academic and professional staff. This section does not provide for the form in which the committee should take. Council also submitted that Section 20 of the law, which provide for removal and discipline of academic and administrative technical members of staff. Again, no format for its report has been provided. There is also no mention of terms of reference, membership composition, and time frame of submissions of report. The condition of service is a contract document and rule of court. And role of the court is to interpret the terms of the contract really entered into by the parties. The court does not add or subtract. On this, Council refers to the case of Council asked the court to hold that the report signed by the chairman and secretary is proper and valid report, as they are key officers of the committee. The signing of official document by two persons in the university system is a practice acceptable. The report being the product of an official action, there is presumption of regularity in favor of all the acts of official bodies. the signing of the report, claimant secretary does not show render report irregular or invalid. This is because the establishment committee is a standing committee of the Senate. According to council, the establishment committee is a standing committee of the council whose membership is drawn from unlike the from he put dash dash council did not provide from where. Unlike the investigation panel that is constituted investigated a particular staff at a time. The SDC is permanent to investigate every member of staff that has been referred from the AIP to SDP. Sit on council to hear all such staff and make verdicts one by one. At the end of investigation is chairman. The secretary can sign the report for and on behalf of the SDC. Council refer to the case of he put dash dash, the case was not supplied, and submit that unless there is specific provisions requirement that otherwise the signature of the claimant and secretary will be sufficient for the submissions of the report. There is also presumption of regularity in favor of such public document, coupled with the certification done. Council asked the court to hold and dismiss the suit of the claimant. Court decision. I have carefully considered the general form of complaint commencing this suit and its accompanying processes, the statement of defense, and the evidence adduced by the parties at the trial, as well as the written and oral submissions of counsel for the parties. The fact that led to the filing of this suit are straightforward and not complicated. By the letter dated 21st day of March 2016, the claimant joined the services of the first defendant on probation as a senior lecturer in the Department of Philosophy. The appointment of the claimant was confirmed on the 8th day of April 2018. Apart from the regular lectures, the claimant was appointed into several administrative positions in the service of the first defendant. The claimant was promoted to the rank of professor, associate professor by the council of the university. See Exhibit CW1A, CW1B, CW1C, CW1D, CW1E, F, G, and K. According to the claimant, his problem started when a final year student, Miss Glory Monday Akpan, by Exhibit CWL, dated 18th day of February 2019, appealed to her graduate with her classmate, which computation was denied by the claimant. By the letter dated 19th day of February 2019, attached to the said exhibit. Upon this refusal, the student by Exhibit CW10, also Exhibit DWB, with the third defendant's minute, the said Glory Akpan petitioned the third defendant against the claimant alleging sexual harassment. The committee was set up to investigate the issue. After investigation, the committee found the allegation to be false, hence exonerated the claimant. After the failure of the allegation to indict the claimant, then there came multiple petitions. As a result of this, the third defendant set up administrative panel of inquiry and established disciplinary committee made up of persons with definite purpose. According to the claimant, though he appeared before both panels, the content of the panels and disciplinary committee reports mostly are the questions and answers of the persons who appeared before the committee does not represent the true questions and answers before the panels. The content were doctored or specially suit the desire of the defense. The claimant alleged that the defendant did not comply with the provisions of staff disciplinary committee in the conditions of service of the first defendant, Exhibit CW1B and DWH. The claimant further stated that both reports of administrative panel and Sub-Disciplinary Committee, Exhibit DWA and DW2A, respectively, did not meet the requirements of the provisions of paragraph 3F2 of the Conditions of Service of Akwa Ibom State University 2018 Exhibit DWH, in that whereas the administrative panel of inquiry report tendered as Exhibit DWA is undated, which raises doubt as to its authenticity. The Sub-Disciplinary Committee report tendered as Exhibit DW2 did not contain the names of the committee members and was not signed by all the members. There is also overlap of the panel members of both administrative and Sub-Disciplinary Committee. This negates the principle of fair hearing and natural justice as contained in Section 36 of the Constitution as amended. See also paragraphs 24, 25, 26, 27, 28, 29, 30, and 31 of the Statement of Facts. For the defendant, the claimant was appointed as lecturer in the Department of Philosophy. In the course of his complaint, he was appointed head of department. He was also promoted to the rank of associate professor. During the 3 years stint he had with the defendant, several petitions were received against him by his students. The complaints against the claimant include sexual harassment, collection of school fees, and embezzlement of the fees. Other complaints include dismissal and termination in his previous employment, and compelling students to pay 700 as against 500 approved by Senate as department fees. See Exhibit CWC, CWL, CW10, and DWB, DWI, DWM, and DWK. Consequently, the claimant was queried, and he replied to the query. See Exhibit DWL, DWK, DW1CS, CW1S, and CW1R, and DWR. Thereafter, he was suspended. See Exhibit CW1T. A panel of investigation was set up by the Vice Chancellor. The claimant honored the invitation. The persons who made allegations were invited. The case of the claimant was also referred to the Staff Disciplinary Committee, an arm of the Council of the University. The reports of the committee were tendered and admitted in evidence as Exhibit DWA and DW2, respectively. The Governing Council then sat and reviewed the two reports and made an assessment of the entire case and report against the claimant. The claimant was offered ample fair opportunity in line with the conditions of service and in line with the general provisions and requirement of the fair hearing. The allegations against him were made known to him in writing. He was given opportunity to respond in writing. He appeared before the two panels of inquiry. He was given opportunity to confront his accusers. The claimant was dismissed based on the overwhelming evidence of gross misconduct against him as shown above. The allegation that the then Vice Chancellor hated him is therefore false. The gravamen of the complaints of the claimant is that he was queried based on petitions written against him. He replied and answered the queries. A panel of investigation was set up by the third defendant to investigate him. He was invited via a text message to appear before the panel of investigation. He appeared before the panel of investigation where he was abused by the panel members. At the panel sitting, he was not allowed to ask questions. He submitted certain documents. He saw the report of the panel with his lawyer as it was attached to the defense. He is not aware students were invited. He did not see the student at the panel, but saw them at the ante room. After the investigation panel, he was invited to appear before the staff disciplinary committee, which he honored the invitation and appeared. That some members of the panel of investigation were made members of staff of the disciplinary committee. The committee recommended his dismissal to the governing council, which accepted the recommendation and dismissed him. The dismissal was in violation of the rules and regulations. DW2 under cross-examination stated that she served as secretary of the staff of the disciplinary committee. The claimant appeared before the committee. At the end of the report of the committee was sent to the governing council. When asked about the composition of the members of the committee, he stated that there were 13 members. There were 13 members, including herself, but he can only remember names of 2 members, late Professor Omoite and Professor Inyoyoka. The claimant quarrel with his dismissal is predicated on the fact that most of the members that sat in the investigation committee also sat in the staff disciplinary committee. This, according to claimant, is violation of the fair hearing, as they say they serve on appeal in their own decision. For counsel for the defendants, there is sufficient evidence to show that the claimant was indeed afforded fair hearing before his dismissal from teaching service of the first defendant. As the panel of inquiry or investigation is a fact-finding panel, its primary mission is to investigate allegations of infractions made against a staff of an establishment. It is unlike a court of law. It does not embark on trial and conviction. Its mission according to counsel, the 2 administrative bodies went beyond the surface and carried out thorough investigation of allegations that were made against the claimant. He was invited. His accusers were also invited. He was given opportunity of making representations at the panel. Counsel for the defendants insisted that the claimants insisted that Exhibit DWA, DW, and DW2A have satisfied what the law requires of them as an administrative bodies and panel of inquiry. Counsel further submitted that the defendants have duly complied with the procedure for discipline laid down in Chapter 3 of Exhibit CWH, DWH, conditions of service governing employment of the claimant as claimant was queried. Thereafter, a panel of investigation was set up where he appeared. Thereafter, he appeared before the staff disciplinary committee, where he was afforded opportunity to defend himself. From the pleadings and evidence before the court, the main grounds of the claimant centers on the alleged non-compliance with the defendants by the defendants to due process in dismissing him from the service of the first defendant. From the service of the first defendant, in that there was violation of his fair hearing in the conduct of the disciplinary procedures adopted by the defendant that culminated in his dismissal from service. The claimant insisted this suit was instituted purposely to challenge his disengagement from the service of the defendant on the grounds that the procedure laid down for
I'm sorry, my lord. My lord, we are no more hearing you. My lord, I'm sorry, we are no more hearing.
He will soon unmute himself. If you check, his mic is muted. There's a reason for it. I don't know. Maybe the device is giving him issue. Just exercise patience. His mic is mute.
Sorry, Council, for the interruption again. I continue where I stopped. It is well settled position of the law that impose the law imposed or applicable as at the time cause of action arose is the law applicable in determining the case. See Uti versus Onobie, see also Okonko versus Okonko, see Obiobi versus Central Bank of Nigeria. This matter was filed in 2022 or in 2020. The applicable law will be the law applicable as at the time the cause of action arose. The decision would be guided, would be the decision would be unaffected by any subsequent changes to the law. See our more limited versus Martins. To ascertain the time the cause of action accrued in this action, the claim before the court and the pleading supporting the claim are the materials to be considered. In this case, the claimant is challenging his dismissal from service, which took place on the 30th day of January 2020. See Exhibit DWQ. See also paragraph 1 of the statement of fact. This means that the applicable law to the claimant's suit or cause of action will be the law applicable to his employment as at 30th day of January 2020. From this finding, therefore, the Akwa Ibom State University Law 2022 is not applicable to this suit because as at 30th day of January 2020, when the claimant was dismissed from service, the said law has not come into force as it was yet to be given birth to. As at 2020, the law imposed as at the time of accrual of the course of action is Akwa Ibom State University Law 2009. This means that the applicable law in this case will be the 2009 law and the 2018 conditions of service. It is settled law that there are three categories of employment, which are: one, employment regarded as purely master and servant; two, those where a servant is said to hold office at the pleasure of the employer; and three, those where the employment is regulated and governed by statute, often referred to as having statutory flavor. See Olanion versus University of Lagos. See also Olarewaju versus AfriBank Nigeria PLC. See also CBN versus Iguilo, where the Supreme Court explained that an employment is said to have statutory flavor when the appointment is protected by statute or laid down regulation made to govern the procedure for employment and discipline of employee. When the employment is found to have statutory flavor, the employee is in essence enjoys a special status which is beyond that of the master and servant relationship. And in order to discipline that person or employee, the procedure created by that statute must be followed to the latter. See University of Ilorin versus Abe. See also Kulle versus Kulle or CSAN versus AfriBank PLC. See also Controller General of Custom and others versus Gusau. In this case, the claimant was employed by the governing council of the first dependent. Six dependent in this case. By the letter dated 21st day of March 2016, which was tendered and admitted in evidence as Exhibit CW1A. As senior lecturer in the Department of Philosophy and Salary Grade Level on WAS 5, Step 2, the claimant's employment was confirmed as per Exhibit CW1B. Thereafter, the claimant served at various capacities. See Exhibit CW1C, CW1D, E, F, G, and J. The claimant was promoted to the rank of associate professor as per Exhibit CW1K. The governing council of the first dependent, that is the sixth dependent that employed the claimant, was established by the Akwa Ibom State University Law 2009. The governing council of the first dependent, sixth dependent in this case, is saddled with the responsibility of to employ, promote, control, and discipline members of staff of the first dependent. The first dependent pursuant to the provisions, the sixth dependent pursuant to the provisions of Akwa Ibom State University Law made Exhibit CW1B and DWH the conditions of service. The conditions of service. The claimant, having been employed by the governing council of the first dependent as an academic, his employment is governed by Akwa Ibom State University Law of 2009 and the conditions of service of Akwa Ibom State University, 2018. The Akwa Ibom State University Law 2009 had made ample provisions on procedure for employment, promotion, and discipline of academic staff of the first dependent. A careful perusal of the provisions of Section 20 clearly shows that employment as an academic or administrative or professional staff falls within the category of employment that has statutory labor. In coming to this conclusion, I took a holistic view of exhibits CW1A, CW1B, and CW1K, and the provisions of the Upper Ibom State University Law 2009, pursuant to which the claimant was employed by the governing council of the first dependent in exercise of the powers conferred of it by the said law. This is because in determining the question whether an employment has statutory labor or not, the court must look at the construction of the contract and the relevant statute and the relevant statute applicable. See the case of Ajabo versus Honorable Minister of Communication and others. In this case, the Court of Appeal affirmed what has been the law. Thus, I quote, the contract of employment enjoys statutory labor where its conditions are governed by provisions of statute or regulation derived from the statute. The court went further to state that the mere fact that an employer is a creation of statute, or that it is a statutory corporation, or that the government has shares in it, does not elevate its employment to that of statutory labor. Rather, there has to be a linkage or nexus between the employer's appointment with the statute creating the employer or corporation. See also Pakode versus OAU. See also Idoni Boye Ogu versus NNPC. Additionally, an employee who claims wrongful termination of his employment with the statutory labor must prove the following materials fact: that he is employee of the dependent, that the terms of employment, conditions of his employment, the way and manner by whom he can be removed. See the case of Ujam versus IMT. In the case at hand, the claimant is relying on the provisions of section in the provisions of XBCWB and DWH Conditions of Service 2018 to press home his claim. Let me say here that the provisions of the law which establishes the defendants and clothes them with power to employ, promote, discipline, and the employees clearly invest employees with legal status, a status which makes it its relationship with the dependents to certainly go beyond the ordinary or mere master and servant relationship. The claimant's employment was pursuant to XBCW1A and promotion and provisions of establishing the dependent. This is because the employment was in the exercise of power conferred by law on the governing council of the first dependent, the sixth dependent, that made the said employment. This means that the employment is protected by statute. See also Federal Capital Territory Authority versus NIB. See also CBN versus Iguilo. See also Comptroller General of Customs versus Gusau. My finding on the status of claimant's employment with the dependent is in line with the Supreme Court decision in a plethora of cases, to which effect that for an employment to be deemed one with statutory labor, it must have statutory enforcement or at any rate be regarded as mandatory to be directly inapplicable to the employee or persons of his cadre, to be seen to be intended for the protection of that employment, and for have been breached in the course of determining the employment before they can be relied on to challenge the validity of the determination. See Olanian versus University of Lagos. See also Epereku versus University of Lagos. See Bamboe versus University of Ilorin. See also UMTH versus Dawa. See also Shitabe versus Public Service Commission. See also Achibong O Udo versus Cross River State Newspaper Corporation and others. See also Mrs. Pakwa de OAU. See also Emolome versus Wayek. See Tamwenu Idonibe Ovu National Petroleum Corporation and Controller General of Customs. The term statutory labor means covered by statute. Thus, an employment will be taken as enjoying statutory labor when it is covered or governed by statutory provisions in every material particular as to the appointment of the employee, termination, dismissal, and other sundry conditions. The C. Adegoke versus Osun State College of Education. The employment of the claimant having been made by the governing council of the first dependent in the exercise of the power conferred on it by the Akwa Ibom State University Law 2009 is one that has statutory backing, thereby elevating it above ordinary master and servant. Having found that the claimant employment to be one less with statutory labor, for the defendants to discipline the claimant, they must do so in compliance with the laid down procedure for removal of the claimant as stipulated in the statute and other conditions of service applicable to his employment. Which must be in conformity with the statute establishing the office of the claimant, i.e. the Akwa Ibom State University Law 2009. It is only when the action of the dependent is carried out in compliance with the statute, that the action can be sanctioned and approved by the court. The law is settled that the only way to terminate a contract of service with statutory labor is to adhere strictly to the procedure laid down by the statute. See the case of Bamboy versus University of Ilorin. See also Olatun Bosu versus NISA Council. See also Iderima versus River State Civil Service Commission. As pointed out earlier in this judgment, provision has been made in the law establishing the dependent or removal of academic staff, like the claimant in this case. See Section 20 of the Akwa Ibom State University Law, 2009. This means that for the dependent to locally discipline the claimant, the provisions of Section 20 must be complied with. This is because for the employment enjoying statutory labor to be determined, the provisions of the statute regarding the termination of the employment must of necessity be determined in the way and manner prescribed by the relevant statute, and any other manner of determination inconsistent with what the statute has prescribed would be null and void. See Iderima versus River State Service. See Imolome versus Wake. See Olanion versus University of Lagos. See Shitabe versus Federal Public Service Commission. See Public Service Commission. Employment that has statutory labor can only be terminated in the manner allowed by the very statute that provided for it. See Osisian versus Afribank PLC. See also Bamboy University of Ilorin. The only way to terminate a contract of service with statutory labor is to adhere strictly to the procedure laid down in the statute. See Bamboy University of Ilorin. See Olatubo Nisa Council. Before proceeding to consider the case of the claimant, it is apposite at this juncture to refer to the Section 220 subsection 9 of the Akwa Ibom State University Law. This is necessary due to the heavy reliance by the parties on the conditions of service 2018, Exhibit CW1B and CW1. Section 209 provides, I quote, the provisions of this section shall not prevent the council from making regulation for the discipline of other categories of staff and workers of the university as may be prescribed. It is clear from the provisions of this subsection 9 of section 20 that Exhibit CW1B and DWH, the conditions of service 2018, does not apply to the academic staff of the case dependent, as from the provisions of section 20, subsection 9 of the Akwa Ibom State University Law 2009, the power to make rules and regulations for discipline was granted to the dependent irrespective of other members of staff not covered under section 20 of the Akwa Ibom State University Law 2009. This also goes to show that reliance on XBCWB and DWH by the parties in this case was based on great misconception or law. Now, I now turn to consider the propriety or otherwise of determination of the claimant's employment. It is clear from the fact pleaded by the parties and the evidence adduced before the court that the dismissal of the claimant was predicated on acts of misconduct. This being the case, the claimant whose contract of service is backed by statute is entitled to undergo the process stipulated by the provisions of section 20 of the Akwa Ibom State University Act, University Law 2009, before his employment can be lawfully and properly be determined. The defendants have made heavy weather on claimants collecting money from students into his personal account, selling unauthorized books to students, tampering with examination results, and not being eligible for employment because he was once dismissed from service by Redeemers University. It is to be noted that this court There is no doubt from there is no doubt from the catalogue of infractions leveled against the defendant as per the petitions and queries issued to him regarding his misconduct, that indeed they are weighty, the allegations are weighty in nature and deserve to be looked into for appropriate sanction to be meted to serve as deterrence for those who may want to follow his path. I am really astounded with the with the allegations against the claimant, and they goes to show the rotten decay in our institutions of higher learning. And this kind of misconduct should not be condoned, must be addressed by sanctioning the offenders so as to serve as deterrence. Be that as it may, it is to be noted that this court is not sitting on appeal on the decision of the council to dismiss the claimant from service of the first defendant, or to found him guilty, or to affirm the finding of guilty, finding of guilty by the council, by the governing council. The concerns of the court is to determine the propriety or otherwise of the dismissal of the claimant must be confined. The duty of the court in determining the propriety or otherwise of dismissal of the claimant must be confined to the compliance with the procedure laid down by law, not taking such action procedure laid down by law in taking such action in dismissing the claimant. It is right that an employee claiming or seeking voiding his dismissal from service must be able to convince the court by establishing that termination of his employment is unlawful. This burden is discharged by the employee proving that he is employee of the dependent, the terms and conditions governing his employment, who can appoint him, who can remove him from service, in what circumstances the appointment can be determined by the employer, and how the terms and conditions of service were breached. See Okomo Oil Palms Oil Company Limited versus Isaiah Rain. See also Emokpe versus University of Benin. See also Amadou versus Amode. See Adeniran versus Nepa. See Ola Pungosu, Oloruntoba Oju versus Abdurrahim. I have earlier in the part of this judgment found that the claimant's employment enjoys statutory flavor. This means terms and conditions of service governing the employment of the claimant are specifically provided for by the statute or regulation made thereunder. With the above finding, I am now saddled with the task of considering whether procedure adopted by the defendant in dismissing the claimant from service has followed the due process of law as encapsulated in the statute investing the claimant with the statutory flavor. To put it differently, whether the applicable statute and conditions of service or regulation governing employment of the claimant were duly complied with by the defendants in dismissing the claimant from service. This is because in determining contract of employment with statutory flavor, the letter of the law must be followed, as any infraction or non-adherence to the procedure laid down would render the exercise resulting in termination null and void and of no effect whatsoever. See the case of Adenim versus Governing Council, University of Governing Council of Yaba College of Technology. See also Olanian, University of Lagos. Section 20 of the Akwa Ibom State University Law 2009 has made ample provisions for disengagement of a member of staff of the defendant who is an academic, administrative, or professional staff. The claimant in this case is an academic staff. The provision of Section 20 of the Akwa Ibom State University Law applies to the defendant, to the claimant. University, it reads, subsection 1, if it appears to the council that there are reasons for believing any person employed as a member of academic, administrative, or professional staff of the university, other than the vice chancellor, should be removed from his office or employment on the ground of misconduct or his inability to perform his function of his office or employment, the council shall A, give notice of those reasons to the person in question, B, afford him an opportunity of making representation in person on the matter to the council, and B, if he requests or any 3 members of the council so request within the period of 1 month beginning from the date of the notice making arrangement to A, for disciplinary committee to investigate the matter and report on it to the council, and 2, for the person in question to be afforded opportunity of appearing before and being heard by the disciplinary committee with respect to the matter. And if the council, after considering the report of the disciplinary committee, is satisfied that the person in question should be removed, as Apo said, the council may so remove the person by any instrument in writing signed on the directives of the council. It is clear from the above quoted provisions of the Upper Ecom University Law 2009 that the provision is very clear and unambiguous and need no any aid of interpretation. Section 20 clearly vests disciplinary power in the council, in the governing council of the university. Provided that such powers are to be invoked if it appears to the council that there are reasons for believing that any person employed as a member of the academic or administrative or professional staff of the university other than the vice chancellor should be removed from office or employment on the ground of misconduct or inability to perform function of his office or employment. The provisions of Section 20 of the law require council to give notice of the reason which make it appear to the council that disciplinary power should be invoked to discipline the person in question and afford, but the council must also afford him an opportunity of making representation in person on the matter. it is clear that the council has a duty to act judicially, going by the provisions of Section 20 of the law. The Apex Court has, in the case of Bamboy versus University of Ilorin, in considering Section 15 of the University of Ilorin Act, which is impari material with Section 20 of the Upper Ibom State University Law 2009, has categorically made it clear that the power of removal of persons to whom the section applies cannot be delegated by the council. This clearly goes to show that the Council of Akwa Ibom State University, to whom the law has entrusted with the power of discipline of erring academic staff like the claimant in this case, is not permitted by law to delegate its responsibility by any ad hoc panel or committee established by the conditions of service, as the said condition of service does not even apply to the claimant in this case. Even if it is applicable, it is not capable of donating such power to the panel or committee in the face of a substantive law, as the conditions of service is inferior to the provisions of the law from which it derives its power. See Bamboy versus University of Ilorin and the recent Court of Appeal case. In the recent Court of Appeal and reported case of University of Jos versus Uwanko, the decision of which was delivered on the 27th day of January 2025, 27th January 2025, where in appeal number CA/J/307/2029. As pointed out above, it is clear from the above provisions of the law that the power to exercise disciplinary action on any member of staff of the dependent who is an academic like the claimant in this case is vested solely on the council of the university, and there is no power to delegate such council. Therefore, the council must be the one that should exercise the said power. The case of the claimant, as can be gleaned from his pleadings as contained in paragraphs 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, and 34 of the statement of fact is to the effect that the defendant does not comply with the regulations in termination employment, with in termination of in dismissal in his dismissal from service, as this right to fair hearing, as his right to fair hearing was violated by the procedure adopted by the claimant in dismissing him from service, while the defendant maintains that due process was followed, as the claimant has appeared before the two committees and his termination was by the counsel of the first defendant. A careful perusal of the defense of the defendant will clearly show that there is infraction of the provisions of Section 20 of the Akwa Ibom State Law, which vested in the governing council of the university to take charge of conduct of proceeding of disciplinary action on alleged misconduct on the claimant. The council clearly, from the evidence, the council was clearly excluded from performing its duty by the third defendant by directing issuance of the queries to the claimant and setting up panels and committees to investigate the claimant. This is a clear usurpation of the powers of the governing council as donated to it by the extant substantive law, Section 20 of the law repassed. The third defendant took charge by directing issuance of queries to the claimant. He also set up investigation panel for the staff and disciplinary investigation panel. Thereafter, the report was forwarded to the staff disciplinary committee, which also conducted its own hearing. This undoubtedly shows that council never notified the claimant of the allegation of misconduct or even invited him to appear before it to defend himself, as it was done in the case of Bamboy versus University of Ilorin. This also goes to show that, contrary to the assertions of the defendant, the claimant was never accorded fair hearing by the governing council of the first dependent, as he was never notified of the allegations of invitation to appear before the council to defend himself by making representation. It is also clear from Exhibit DWQ letter of dismissal that the council relied on the two reports received from the panel of the investigation and the sub-disciplinary committee, which it reviewed in dismissing the claimant. This also has gone to show that the claimant was never accorded fair hearing by the council, as he was never invited and never appeared before the council. The action of governing council, therefore, in dismissing the claimant based on the two reports is unlawful, invalid, null and void, and of no effect, as the decision was reached in violation of the extant provisions of the law establishing the governing council and empowering it to discipline the claimant. The reason being that generally a statutory disciplinary power cannot be delegated. Such power can be delegated where there is express statutory authority to do such delegation. And in the case at hand, there was no such statutory authority which authorized such delegation. In the instant case where the power of the council of the first dependent to discipline administrative, academic, professional staff of the university under Section 21 of the Akwa Ibom State University Law cannot be delegated or usurped. The council must be allowed to exercise the powers conferred on it by the law and not to be taken away by anybody or person. See Bamboye versus University of Ilorin. Since the procedure for removal of any person employed as a member of academic or administrative professional staff of the university other than the vice chancellor is specifically provided for in section 20 of the university, it seems to me that the procedures stipulated in the conditions of service SBCW1 B and DWH are not applicable in this case, more particularly when there is no express provisions made by the statute allowing such to be used. This means the express mention of one thing is the exclusion of other things. See the case of Koropo versus Emeka, and Attorney General of Abia State and Attorney General of the Federation. Since the university, the conditions of service is not applicable, it cannot be used to determine the propriety of otherwise of the dismissal of the claimant. All that is needed, since the claimant employment is that of statutory labor, is adherence to the provisions of Section 20 of the Akwa Ibom State University. See the cases of Bamboe University of Lorin Supra, Adeni Governing Council, Yaba College of Technology. See also Olatu Boson Naisa. See Kwara State Polytechnic versus Saliu. See also MBTE versus Anyawu. See also Kwara State Polytechnic Lorin versus Shitu. See also Olanian University of Lagos. See also Oloro Tuba Oju versus Abdurrahim. The provisions of Section 20 of the University of the Akwa Ibom State University has made it clear beyond peradventure that the process for removal of a member of academic and administrative staff or professional staff of the university, other than the vice chancellor, must begin with the council and also conclude with the council. But what can readily be gleaned from the record of the case before the court is that the process is leading up to the dismissal of the claimant was not initiated by the council of the university. It was initiated by the study dependent, the vice chancellor. Who also set up the investigative panel and thereafter forwarded the report of the investigating panel to the staff disciplinary committee, which also sat and came out with its own report. All this clearly shows that the council was not involved as at that level. The council was only involved when the report of the when the two reports were forwarded to it by the vice chancellor for consideration, and the council did not bother to notify the claimant of those allegations contained in those exhibits. It proceeded and determined the employment of the claimant in violation of his fundamental right. This clearly shows that the claimant was never granted any fair hearing. Appearing before the two ad hoc committees does not amount to giving him fair hearing. In fact, the counsel for the claimant seems to have alluded to this in his paragraph 3.5, 4.35 of his final written address, where he stated that the panel of investigation and the sub-disciplinary committee were a fact-finding committees. They were not a court of law. They were not bound by the doctrine of natural justice, but they abide by it. They go out of their way and abided by it and conducted a thorough investigation and found the claimant guilty and recommended him for dismissal, which the council rubber stamp and dismisses the claimant from service. It is to be noted that the council of the university is not a rubber stamp. It cannot just rubber stamp whatever the committee has sent to it. It has a duty under Section 20 of the Act to ensure that the claimant was given fair hearing by notifying him of the allegation against him and giving him opportunity to appear to defend himself before the council. That has never taken place in this case. Therefore, the council did not abdicated its duty and refused to follow the law and decided to follow the wishes of the third defendant. To adhere to the doctrine of fair hearing as encapsulated in the Nemo Judex Inca Causasua clearly shows that the claimant was not given fair hearing. assuming but without considering that Exhibit DWA and Exhibit DWA and DW2A were properly and legally made. They cannot still be of any value to the court, as they do not have any evidential value. For Exhibit DWA, it was a document that was not dated, and a law undated document has no evidential value. It is as worthless as any piece of paper. And for Exhibit DW2A, the report of the staff disciplinary committee, it was the members of the committee comprised of also members that sat on the panel of investigation. At least the DW2 under cross-examination has admitted that Professor Omoite, one of the members that sat in the panel of investigation, was also a member of the panel of investigation, who was the panel of the staff disciplinary committee. By including him in the committee alone has gone to nullify all the proceeding of the committee for a likelihood of bias from the In the circumstances, the two exhibits or the two reports of the panel and committee have no any evidential value in the eyes of the law. In this judgment, I hereby discountenance them for the purposes of this judgment. With even discountenancing these two exhibits, it means there is nothing before the court to show that the claimant has been accorded fair hearing, since the council of the university did not even notify him of any allegation against him, and did not also accord him any opportunity to defend himself before the council, which is mandatory requirement of Section 20 of the Akwa Ibom State University Law 2009. In view of the finding that the claimant was not accorded fair hearing, the claimant succeed in his claim before the court, and his dismissal from service must be nullified.
We're not hearing again, please. Hello, technical control. We are not hearing anything again at this end. Thank you.